Having reviewed the cases presented by the defense concerning the downward departure, also as well the argument that has been presented, the court has reviewed its notes of the trial and will rule on the issue of downward departure at this point. Florida Supreme Court has a two-part test concerning whether a downward departure should be granted or could be granted by the trial court. The first is whether the trial court can impose a downward departure sentence based on a valid legal ground proven by a preponderance of the evidence. The second step is whether the trial court decides whether it should impose the downward departure based on the totality of the circumstances. As to both the non-statutory grounds that have been argued and the grounds contained within Section 921.0026, subsection 2, subsection B, in reviewing the trial court's notes, what has been argued by both the defense and also as well the court's relying on the record itself, court will find that there is a ground for non-statutory downward departure, but it declines to exercise its discretion. As to the statutory ground, I will find that both the defendant was an accomplice to the offense and a relative minor participant in the criminal conduct. I will find that has not been proven, but in addition to, the court would still decline to exercise its discretion. As to the sentence in this matter, Ms. Adelson, please rise. Level of planning and coordination to bring the murder of Professor Markel to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub A Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
$2,100 as a fine pursuant to section 775.083, $105 as the 5% surcharge required by section 938.04, $20 as a court cost pursuant to section 938.06, crime stopping trust fund, $3 as a court cost pursuant to section 938.01, subsection 1, criminal justice trust fund, $50 pursuant to section 938.03, crimes compensation trust fund, $225 pursuant to section 938.05, local government criminal justice trust fund, $2 as a court cost pursuant to section 938.15, county criminal justice education, $50 as a court cost pursuant to section 775.083, subsection 2, county crime prevention, $65 as a court cost pursuant to section 939.185, county additional court costs, and $3 as a court cost pursuant to section 938.19, teen court assessment.
Is there any lawful objection by the defense to these assessments?
No, Your Honor.
They will be assessed at this time. The cost of prosecution, the court will reserve jurisdiction on to determine for 60 days. If a hearing needs to take place concerning this matter, that will take place at a future time. As the defense's request for the court to make a recommendation to the Department of Corrections to place Mrs. Adelson in a facility near Miami-Dade County, I have no problem making this recommendation. The Department of Corrections will have the final say because this is an administrative matter. I will also recommend to the department that Mrs. Adelson is not to be placed in any unit or facility that would also house Catherine McVanilaw. The court did previously award to the state, based on the September 17, 2024 continuance of the trial, costs that were related to that. Ms. Kappelman, part of what you're seeking to pursue, is that included within that, or is that a separate number?
Are you speaking of the costs that were ordered in Charlie Adelson's trial?
No. The day Daniel Rashbaum withdrew from the case and the trial had to be continued.
Okay.
All costs related to moving witnesses and other matters.
Yes, sir. I don't know the answer to that, but I'll make sure that they're only in there once.
Very well. The defendant is to be fingerprinted, 30 days to appeal. Please file the appeal promptly.
Your Honor, may I approach the clerk? We have put I have written on the letters that I had, so we've put a composite together and I've shown it to Mrs. Kappelman, who has no objection.
Please place the sticker on them so that way they can be admitted.
No objection.
We are in recess. Seven, 8, 2.